Welcome to Laid Back Law with your favorite lawyers from around the interwebs, discussing the most pressing of topics every Friday at noon Eastern Time.
All right, we're live. There's a couple of us here. We're, as usual, waiting for everybody to come in. Before people say, Eric, what happened to your face? Sometimes things happen and you see a dermatologist and they want to remove things from you that were once part of you, but my face will come back pretty soon. I just want to address that early because I know how that goes. What's with his face? What are those dots? I know on America's Untold Stories, we like to find the dots. I'm just wearing a couple of them now in spirit of that. So Phil, let's go ahead and jump on to what you're covering. I know that you've done a bunch of hits with Fox. You just did a hit with Fox, I think yesterday or the day before, about the, I don't know, do we call it a war?
I call it Lawfare 3.0 because
okay.
So that's what we're seeing. So we'll just jump in there. So you've got, I mean, I don't know. I think we're up to, 70 or 80 lawsuits now that have been filed by the left against the Trump administration for their efforts to do everything from, cutting wasteful spending to hiring and firing of executive branch employees. I believe that, and there's some documentation and some ideas floating around, particularly on X or Twitter, about this all flowing back to George Soros kind of money. But the bottom line is this: the left has found out over the last couple of years that they can use courts and willing judges to implement, an agenda. And
this has been going on for longer than that, though. I mean, the left and gay marriage, for example, running through the courts.
Oh yeah, well, and that's true. I'm specifically referring to the lawfare with respect to the anti-Trump. Anything to Orange Man bad. They get the courts to do their bidding, and so what they're, it's no secret, it's no accident that the federal district courts, that's in DC, the district courts in the federal district there, it's no secret that those positions, those seats on the bench are filled with, Obama and Biden appointees and people that are willing to, act in a partisan manner as opposed to the way they're supposed to act. And so the jurisdiction for agency actions, of course, lies in the federal district court there in DC. So, these plaintiffs, they find these willing judges to do their bidding. And of course, by the time it can get up on appeal, they have largely slowed down, if not stopped, some of the policy goals of the administration. So it's Lawfare 2 or 3.0, maybe 4 by now. It's hard to keep up. But at the end of the day, the idea is that the federal courts, cannot run the executive branch. It is okay to have judicial review. Courts know that they have that power. And if the president or if Congress acts in an unconstitutional way, judicial review is appropriate. But that doesn't mean, Eric, that the courts are able to substitute their judgment for that of the president. Just because they don't like something that the president may be doing doesn't mean they get to substitute their will and impose their will and essentially run the executive branch. It's a clear problem when it comes to separation of powers. The Constitution says that the executive power of the United States shall be vested in the president. Okay. And everybody else that works for the president, none of them are elected. Everybody's complaining about Elon's not elected. Well, nobody's elected other than the president and the vice president. And the vice president essentially has no role technically in the executive branch unless there's some problem with the president. So it's everyone who is subordinate to the president is not elected by definition. And so this whole thing about Elon being unelected and all, it's a red herring and it makes no sense.
Well, isn't there a parallel? Barnes was talking about this on Sunday, I believe, that all the federal courts also, there's nothing stating that they should even exist, only the Supreme Court.
Yeah, that's true. And the way the Constitution is set up, Article 3, it's called the Madisonian Compromise for those of you who are history geeks. they couldn't really figure out how to set up the judicial branch. So the compromise was, well, okay, we'll create in the Constitution, we'll create one court, and it says the judicial power of the United States shall be vested in one Supreme Court. And it then goes on to say, and I can't quote it necessarily, but it's pretty close, in all such other and further inferior courts as Congress basically may deem fit to create. So the courts of appeal and all of the federal trial courts and every court that is subordinate to the Supreme Court, including military courts, admiralty courts, tax courts, all of them, they are all created by Congress. And so that's what Barnes was talking about. And this is something I said yesterday on Fox. You know, these federal district judges, they are created by statute. They are not even contemplated by the Constitution. And so because of that, you know, that just underscores the fact that they do not get to run the executive branch just because they don't like something the president's doing.
So is the main issue that these are subordinate courts? Like if it was a Supreme Court, which is a co-equal branch of government, saying, hey, whoa, stop it, that would be more legitimate than lower level courts stopping the higher level administration, or am I off base?
No, you're not really off base. The district courts don't have to exist. Okay. The Constitution doesn't create them. The president and the presidency, the office, is created specifically, explicitly by the Constitution. These judges that are deciding that they don't like what the president's doing, so they're just going to order him to stop, they were not created. Their jobs, their role, their posts were not created by the Constitution. So yes, they are inferior government employees. In my view, they do serve for life, but they, again, Congress could eliminate those posts if Congress saw fit to do so. For the same reason that the left wants to pack the courts, Congress has the authority to do that. There's nothing in the Constitution that says there shall be 9 justices. There could be 49. It's whatever number Congress puts on it.
So, okay, this may be a dumb question, but what is the recourse? Like if there is something going on in the government, now I happen to agree with a lot of, you know, what's going on in the executive orders or whatever else, but it's not always on the same side. What if it was on the other side and people are saying, whoa, wait a minute, you just did this, you just did that, that's unconstitutional. What is the recourse? Because doesn't there have to be a suit down at a lower court before it can get to the Supreme Court? You can't just go to the Supreme Court and go, knock, knock, knock. Hey, Supreme Court, look, stop this.
Yeah. You can't just start filing stuff directly in the Supreme Court. I mean, there are certain limited, like if Alabama is going to sue Florida or Georgia or whatever, you know, suits between the states and certain other things can be filed directly in the Supreme Court. But Congress, by statute, has set out how federal jurisdiction and the federal courts, work. And so they have designated that, you got to file a lawsuit, and you file it in the trial courts, and then it has to percolate its way up to the Supreme Court by virtue of some kind of an appeal. And historically, that process has taken a long time. It's been pretty cumbersome. I personally am in favor of Congress creating, and it would have to come from Congress. They could create some kind of expedited appellate review for certain of these issues, granting jurisdiction specifically to the Supreme Court and expediting the appeal. And I think that may be what has to happen so that this lawfare stuff can be dealt with more quickly and efficiently by the Supreme Court. I'm sure Nate 100% agrees with me.
No, I disagree with the last point you made, because that's Marbury v. Madison.
What's that?
Isn't that the holding of Marbury v. Madison? The last point that you made about making an inferior court to extend the original jurisdiction to the Supreme Court, that was overturned in Marbury v. Madison. Remember, that was the whole thing about, can you extend, because the original jurisdiction of the Supreme Court is listed in the Constitution. Yes. Just so everybody understands what original jurisdiction is that those are cases that can be brought directly to the Supreme Court. It doesn't have to be brought to the lower courts, which is like Phil said, it's all made up. That's all made up.
Well, my point, but, I probably didn't say it clearly. What my point was, Congress could, I think, create some expedited appellate procedure to get a case more quickly from the trial court to the Supreme Court. Now, I still think it might be a discretionary kind of thing that the Supreme Court doesn't have to take it, but there are certain procedural hurdles that sometimes slow things down so that the Supreme Court can't even look at it until it percolates for a little bit more through the lower appeals process.
Yeah, 1,000%. So what I was talking about with the original jurisdiction is that, like, cases against two states are suing each other, they go directly to the Supreme Court. They don't have to go to a district court.
Right,
But in Marbury v. Madison, that was the question: can Congress can it extend that jurisdiction to writs of mandamus against the executive? Because remember, the executive didn't do the judgeship, and they said no, you can't extend that original jurisdiction. So, and we're going to overturn that thing. I think now the issue is that the first district court had universal jurisdiction over the entire United States when they created the first district court.
Which one was that? I'm
not even sure which was the first district court, because don't forget, the Supreme Court justices, before they were district courts, used to ride what's known as a circuit. So the Supreme Court used to meet the Supreme Court, then used to ride the circuit, and they were essentially the judges. So they would go into this place and judge these various cases. And then that became too cumbersome for just 9 justices, because you had a small thing. So then they extended that to have like the appellate courts, and then they extended to have the district courts. And still, you had the Supreme Court would still ride the, and they do some of that still today, but it's a whole different process. But I'm assuming that this right of making these nationwide bans comes from that authority, because, like, I think you're 100% right in the saying that these inferior courts are made up through Congress, through statute. But I think that authority, by creating them, gives them that authority, because you don't forget, you have Article 3 courts, right, where so an Article 3 court, I feel like I'm going deep into con law. So there are Article 3 courts and there are statutory courts. A statutory judge would be
bankruptcy.
Called? Yeah, bankruptcy. Those are statutory judges. They are not, versus an Article 3 court. Now, Article 3 courts can make rulings on constitutional matters that can affect the whole country. So the district court judges, the appellate judges, and the Supreme Court are known as Article 3 judges. That gives them that authority. And if you're not an Article 3 judge, you don't have that authority. So that's going to be the tension here now. If we're going to change district court judges from Article 3 judges that have the authority to make this decision. Does that make sense, Phil?
It makes sense to me. Yeah, I get it. No, sure.
Well, okay, so just to see if I've got.
I'm sorry, I know I'm using Article 3 and all of this stuff. So
no. I mean, anyway, that's all fine. Is the main issue that they are able to actually stop the administration? Like I think it makes a certain sense that they can make a ruling, but they're not actually enforceable until it goes all the way up the track. If
the rulings they make, right, or whether they rule correctly or not, their rulings are the rulings at the time that the ink is dry on the thing. And so unless a higher court stops it or adds a stay to the ruling or something, it is the ruling, and these rulings out of so when we got an 8, let's say we want to sue to stop the Treasury Department from spending some money. So we're going to sue in the district court for the district of the federal district for the District of Columbia. Okay. Instead of like the Northern District of Georgia where I live or whatever, there's a federal district in the District of Columbia. And so you'll file there in that trial court, because that is where the agency is headquartered. That's the seat of government. So when a district court judge in DC files or issues an injunction against the Secretary of the Interior or whatever from doing something, that is because that's where the agency lives or exists. Okay, so it's technically not a nationwide injunction, but it has a nationwide effect. When you sue out in Oregon, and the Oregon judge issues some kind of ruling, think about like these mask mandates and all that from back a few years ago. Sure. These were district courts that were way outside of Washington, D.C., that were issuing rulings that ordinarily would only apply to the parties involved in the lawsuit directly in front of them. But
so
they would somehow give it nationwide.
Alabama. Right. Alabama is not Oregon or whatever, or Texas isn't Oregon. And that's part of the issue.
But it all depends on how the challenge is brought. If it's an as applied challenge, then it would just affect those litigants. But if you're challenging the constitutionality of the rule, then you could have a nationwide hold if the judge sees fit. Because don't forget, if they're an Article 3 judge, they can make that constitutional ruling because only Article 3 judges can do that nationwide, I should say.
But that's the issue, though.
How
dare this low level? It's kind of like some of the shenanigans that were going on during the election, right? Where you have these like literally effectively a traffic court judge saying, remove Trump from the ballot because I don't like what he did. There is some disparity here, and to be crude, judges getting too big for their britches.
This is like the Vulcan mind meld era, because that was the phrase that was literally in my brain, and I was about to say it. Too big for their britches. But yeah, that's it. They do oftentimes, and not just in this context. My whole career of almost 30 years now, I've witnessed judges doing stuff that they really have no business doing, but they think, hey, I'm the judge, I can do whatever I want.
One thing I'll say, even with all these executive orders, is it's funny how the law kind of comes full circle. Scalia's dissent in Morrison. So for those of you who don't know the Morrison decision, Scalia was a brand new justice on the Supreme Court, and they had the independent counsel that they wanted that Congress wanted to create to investigate the president, and the independent counsel was essentially an employee of the executive branch. And the other 8 judges on the Supreme Court said, hey, we like this law, we're going to let it go by. But Scalia, being a new justice, was like, I don't agree with this. I believe the president should have the power to fire anybody who works in the executive branch under that. Obviously, except for civil servants, because there's a whole other issue with civil servants. The people who actually the aligned people, the people who are actually doing the work. But when it comes to the president, the secretary of whatever, he should be able to fire them at will. So Scalia wrote the dissent. It's called the Morrison dissent. And that dissent, he argued for what's known as the unitary executive theory. And now, 20, 30 years later, we all believe that was the right, everyone now believes that dissent was the right call, should have been the rule. So now Trump's team is going into the Supreme Court essentially arguing that the Morrison dissent should be law, that he should have the power to hire, fire whoever in the executive branch. And I think that's the best argument.
A more recent ruling on that with Biden, and I'm only asking because there's a show called Two Way I watch quite a bit, and Sean Spicer was Trump's former press secretary, but he was working for a group within the administration, and they were going to finish their job in November or something. But anyway, Biden fired them outright, and they sued, saying, "Hey, you can't be doing that." And the courts ruled, "Yeah, he can fire anybody he wishes." So now, I'm just curious if there's more.
Yeah, so it all depends on what level, because there are certain people who can't be fired in the federal government. That's why the firings that they've been making now is to probationary people who are on probation. So if you hire an air traffic controller, there's a probationary period for, let's say, a year or 2 years or whatever that probationary period is. After that period, the Supreme Court says that you now have a right to, it's a property right you have now in your employment. And if they're going to remove that property right, they now have to do it through due process.
Well, I think that creates, in my opinion, an interesting, I don't know the answer how it's going to play out. That's also a separation of power scene, because this is like a turf war. Can Congress force an employee on the executive? In other words, can Congress, within the bounds of the Constitution and separation of powers, can the Congress constitutionally say, Mr. or Madam President, this employee, you can't fire this employee, okay? You must take this employee. You must keep this employee even if you don't want them. And so that's, on its face, that is actually Congress invading the space of the executive branch. And honestly, I think there's in my mind, at least, maybe I'm just crazy. In my mind, that probably goes too far. I don't think Congress really needs to be in the business of forcing any employee on the executive branch.
Well, that goes against the people.
I think we need to break down that when we're talking about removing someone, there's 3 different bases as to where someone could claim is some sort of legal violation when the president tries firing someone, that person claims they cannot be fired. It can be a constitutional basis that the Constitution is expressed for one reason or another, to the extent you can find such a thing, and restricting the president from doing that. It can be a contractual basis. And those are two very, very different bases, because if it's purely a contractual basis, in that case, you would think that's not something that a judge should be issuing a TRO on. That's not something that he should, if anything, that would seem to be potentially a financial basis, which he or she could receive his compensation for being wrongfully terminated in violation of a contract. That's very different from a constitutional basis. The third basis is the one that Phil is aptly touching on right now, which is a little bit murkier. And that is when Congress passes a statute which purports to compel the president to retain someone on his staff. And then you have that question, what is the basis on the Constitution that would enable them to perhaps infringe on the separation of powers that are laid out in the Constitution? The question is, so now if it is a statutory basis, if that can withstand scrutiny by the courts, the question is, even then, would a TRO be the appropriate thing, or is that more a contractual in a constitutional sort of way, or is it more of a contractual type of claim, or is it more similar to a contractual type of claim, where you're forced to have him and go get, and the person can collect their money, but perhaps cannot force their way into their position and retain their job.
Well, some of this too, Joe, if I'm wrong on this. Oh, I'm sorry, Nate. Let me slide it in. I'll get it out because I want to put another factor in there. We had a judge that was literally freezing when they were offering 8-month buyouts, which to me was completely inappropriate, because they were saying, hey, you can leave and we'll pay you money. So they weren't even terminating or firing them. They were giving an option to people. And the judge was still trying to freeze it. But go ahead, Nate. Sorry. Please add that into your mix, though.
Well, I want to make it very clear is that, so there are unionized federal employees, and they've collectively bargained with the government for certain particular rights, right? And some of those rights are permanency after a certain probationary period. Generally, it's 1 to 2 years. So after they complete that 1 to 2 years, then they can only be fired with what most people would refer to as with cause. You can't just fire them. You have to do it with cause. So with those particular, and those are your frontline people. Those are the people when you go to Social Security Administration who are behind the counter. Now, the people who those have been letting go are all the probationary people. They haven't gotten that right, that right to be fired for cause. Now, this is not the issue is that, so Joe is correct when he said this is a contractual agreement, but that's the collective bargaining piece. But then there's also a second piece to it, where the Supreme Court has said, well, when you get to that point where you're now a permanent employee of the government, then you have a property interest. And the only way the government can take away that property interest is through a due process, essentially confirming the fact that you have to release that person with cause. But that's not all employees. That's limited to the frontline employees. So in this particular case,
you're raising a fourth basis, Nate, and I think it's a very important thing, because I do think that this is a theory that plaintiffs are bringing up now, which is a labor law type of theory, which is and when you're looking at it as a labor law type of theory, then you can look at it and say, you could ask the question, is, to the extent that the labor law is now infringing on the presidential separation of powers and whether it's under a unitary executive theory or some other basis, to the extent that it's infringing on his powers as president, can a labor law that's passed by statute have some sort of impact on the president's decision making? And I think that's one sort of congressional decision, which is perhaps not directed specifically at the president when they draft it, but when they try applying it to the president. Because if you think about labor law, right? If everyone thinks about this for a second, there's a lot of labor laws that are out there that are designed to protect the public at large from some private company that may be doing something, whether it's discriminatory or wrongful terminations. So it's in general perhaps a good idea, but then when you try applying it specifically to the president of the United States, in that case, that's where you start drifting into the constitutional issues that Phil was identifying earlier, right? I mean, I think we all could agree.
Yeah, you're 100% correct.
I'll say this. I got to go in a couple of minutes, but I will say this real quick. I think that unionization is a bad idea for many reasons, but unionization I'm talking about federal employees here, But the fact that in order to allow for unionization and provide all the civil service protections that Congress has done by statute, that essentially forces employees on the chief executive, and in my opinion, violates the separation of powers in an unconstitutional way. And I would say if I were the decision maker on the Supreme Court, I would say that the whole scheme of federal unionization is unconstitutional. But that's just me.
I'll tell you this much. I've got my own dad, who's a lifelong teacher, angry at me for saying not just federal employees, but any government employee. If you think about the purpose of what a union is about, no government employee should be able to, there's no basis to have a union. The reason you have a union is because the reason we established unions in the first place, roughly a little over a century ago, was to protect employees from overly aggressive private entities who were looking to abuse them and really were harming the public, and could say, all right, you don't want the job, I'll find someone else to do it. And there was a disparate bargaining power between those private employers who basically had essentially together an oligarchy over giving out jobs. And back then, it's like you were desperate for a job. And they were literally working for 3 cents an hour in coal mines and various other really, really crazy, harsh conditions that no one alive today has ever experienced, or very, very few of us have ever experienced, and paying them next to nothing, practically slave labor. So that's where labor laws came about. That's not the dynamic in any sort of government position. And that's why to say that we need to protect the individual employee from an abusive employing government agency seems insane. That's not an applicable type of concern that we should be that any sort of government ever needed to address in order to protect them from some abusive agency. Plus, here's the main thing, and this is what is so outrageous. When you talk about a private entity negotiating with employees, they have it in their personal interest to try and stand up for themselves and combat the employee. So you need to have, in order to have an equal bargaining power, you need to have the employees be able to band together in a labor so that then they're able to come forward and stand up against that very strong, aggressive employee. That's not at all the case in a government. What happens in a government type of position, think about this for a second, is now when the labor union from the government is negotiating with someone from the government, the person from the government doesn't have nearly the same interest. It's not their own pocket. It's not their own business. The pocket is the pocket of the people. And to that extent, this government agent is standing up for the majority of people. He's not standing up for his own private interests. And if he ends up failing in those negotiations, it doesn't end up really affecting that person personally. So the interest is much, much, much stronger on the side of the labor, and there's no fair bargaining partner standing up for the majority, because to the extent he loses in those labor negotiations, it's really no skin off their back, in contrast to a private entity where it's completely the skin off their back. So now we, the majority, in trying to negotiate against some bus union, the teachers union, postal workers, we don't have anyone who's standing there for us who actually has nearly the type of interest that we collectively have against this relative minority of that government union organization.
But Joe, I totally agree. Can we not? That's like an entire episode sidetrack of a subject, though.
I agree with
on
Bill.
one breath.
My only disagreement with Joe is that each state has their own constitution for a reason. And I think that some states are more likely to recognize that the state power over employees or around what we would normally hire as private contractors is immense, and that power ought to be mitigated by the use of labor unions. So I think it just sort of depends, but I tend to agree with you in principle, especially on a federal level. I don't think that the federal constitution has room for federal unions.
I have to disagree with the panel. I believe that there's a constitutional issue that we're running up against, and it starts with Citizens United. Corporations and organizations are people, and those rights, for instance, the right to free speech. You can speak through labor unions. You speak through donations to your money, and you also have a freedom of association. So federal employees don't lose their constitutional rights because they are federal employees. So they do have the right to associate, the right to get together, and the right to use their money to do all this stuff. And also, there are limitations on public employees. For instance, public employees are not allowed to strike where where private employees are allowed to strike. So I think to say that the Constitution maybe not expressively says there should be labor unions, but I think if you go to the rights of the individuals who work in the government, which they don't lose because they're in the government, then they have the right to associate, they have the right to free speech, and they have the right to put their money together and say, we are going to band together and negotiate as one instead of as individuals.
Except the problem is that
Hey, I got to run real quick.
Right.
I will grant my proxy to Dani when she gets back for the rest of the show.
Sweet.
Gotta head off for some TV. So you guys enjoy your rest of your day. Great show and happy weekend.
Yeah.
Thanks, Phil.
All right. Well, I don't want to dwell on this one because I feel like that's an entire subject to go on. And
my only comment, as I've been doing labor law for over 30 years, government employees are not immune to bad bosses, and there is also a reason why they should and could unionize. Now, the power of the union, that's a whole other discussion.
Oh yeah.
Okay.
Oh yeah. Crazy.
Well, there we go. Well, we got Nik up talking anyway.
Hey.
How about you catch us up? A verdict came in this week, and I would love if you share what went down with ASAP Rocky, but also what the hell the case was, because I know nothing about it other than there was a case out there. It's a guy named ASAP Rocky. So please give me a basic breakdown of who he is, what he was accused of, and what happened.
ASAP Rocky is a famous rapper. He is in a relationship with Rihanna. And a few years ago, he was in an altercation with his friend, or who was in his posse, or whatever you can call it, rally, ASAP rally, where they met up. There was some scuffling, branding a weapon. They walked away, rally followed, and then on the surveillance camera, you hear 2 gunshots, but not exactly where it came from. So that is the basics of it. And of course, the state of California or Los Angeles DA's office decided we are going to charge Mr. ASAP Rocky, because Relly went to the cops with 2 shell casings, which is extremely powerful evidence. Hey, I found he shot at me. Here's the shell casings. And
no, not if anybody didn't see the actual shots take place. I can come up with shell casings.
Yeah, that's the next part of this story is when Relly took the stand and started to testify about this. That if you saw any of the defense or the prosecution witnesses, the alleged gang members in the wild sale trial, if you put them all together as one person, then you have ASAP Relly. It was a Foster clock, complete Foster clock.
I was in the Army. We like to say Charlie Foxtrot.
Yeah, okay. And so it came to be that, these shell casings that you found, yes, those were the shell casings I found. You can see me there on the video. And then it came but all of a sudden it wasn't him on the surveillance video picking up shell casings, because he was dressed differently. No, I didn't go home and change. It can't be me on that. And it is so... trying to condense this, it sounds so ridiculous, but, well, the shell casings he retrieved did not match anything ASAP Rocky had in his home. No, it was the same caliber as ammunition found in ASAP Rocky's home. But ASAP Rocky didn't actually own a 9mm gun. His manager did. And then, Mr. Relly testified to, he has no experience in firearms at all. He has never been to a gun range. And on cross-examination, hey, is that you on that video you posted on your Instagram firing a 9mm gun 2 weeks prior to this?
Boom.
So we're not dealing with the best and the brightest, is what you're saying?
Yeah.
Oh no! And first he decided to claim to the defense that's fake.
Okay. So what was the outcome?
Yeah, and if it is not fake, that's not in Los Angeles. That was back in New York. Oh, really? So then the cross-examination continued on Monday, where they brought forward, hey, that's LA gun range. I don't remember the name of the gun range, but yeah, he was in LA shooting guns 2 weeks prior with 9mm gun. So you can draw your own conclusion where he found the shell casings. And it just got worse and worse and worse. But in all of this, you have the surveillance video of Rocky. You can see him holding a gun. And then a few minutes later, you hear 2 gunshots in another surveillance video. I've seen trials with less evidence reach a guilty verdict. But in this case, after all was said and done, and a juror, just after the verdict, had an interview with, I don't remember her name, where they said, it was because the defense had the defense of, oh, it's a prop gun. The gunshots you heard, and that was blanks being fired. And the jury did not buy that at all. Not at all. Not at all. But what saved Rocky here was the jury instructions, apparently. The jury instructions, according to the jury, said, we believed it was a gun. We believe he fired 2 shots. But about half of them said, we can't go to guilty. And then a few people said, well, it's enough for us to reach guilty. And after some discussions, they came into the conclusion, we can convict him. The prosecution did not prove the elements of the crime.
All right. So did justice prevail in your opinion or no?
Yeah, because it was an absolutely horrifyingly bad investigation. Where
like
they believed Relly on face value, and it came back to bite them.
Okay.
Yeah. So nothing the defense brought forward had any effect on the jury. It boiled down to one of these unique not guilty verdicts where they simply said they didn't prove it beyond a reasonable doubt.
Okay, let's shift to Justin Baldoni and Ryan Reynolds, Blake Lively. Sounds like another Charlie Foxtrot. Dani, I think you're covering that. I don't know, Kurt, if you're covering that at all.
I have been covering it. I've been breaking down the Baldoni complaint in parts because it was so long. I think I've done 3 parts. I think I'm up to page 120 of the complaint because it's taking a while to get through. But it's been fascinating to read, especially with the amount of receipts that Baldoni has already put on the docket, which is unusual in an initial complaint. Normally you don't do that.
Brilliant, though. Absolutely brilliant, because brilliant. I think what they're doing is they said, okay, here's the strategy. She's coming out with this public court amusement, right? So she's going to leak stuff to the press. This is her game plan. And his crisis team knew about this at least by last year, right? So at least by June of last year, by the time the crisis management team gets involved, they're like, look, we're going to hit him hard. We're going to hit him fast. We're going to gather up all these receipts and we're going to hold this in case she decides to pull this kind of stunt, which is exactly what she ended up doing. And so what was clever is that not only did the defense go ahead and release all these documents in coordination with their complaint, they set up an entire website dedicated to this. They have a timeline of events. And what's great about it is they go through and they start debunking all of her claims on day one. They say, look, she came in and she disclosed these text messages. Here are all the undisclosed text messages that provide context for what's going on here. And what was brilliant about this strategy, they came in, hit her so hard. They came in and they said, look, we're not going to leave any survivors. We're not going to take any hostages. This is what it is. And either you drop this litigation, you drop this lawsuit, or we will bury you. And that was the plan from day one. It's brilliant because these, especially litigation like this involving so many powerful players, is going to be protracted, and the punishment is the litigation on its own. So being able to come out strong, hard, and fast and say, you want to play this game, we will win from day one, puts them on an equal playing field when it comes to their negotiation strategy and actually getting this settled outside of court. I don't think their goal is to win and win damages. I think their goal is just to get this settled and get this killed as quickly as possible so that Mr. Baldoni can move on with his life and actually have a career after this.
Yeah,
What about
I'm sorry.
Oh, go ahead, John.
No, Danny's quite correct that this is not about winning the court case. It's about winning the court of public opinion and maintaining their status both in world opinion and also specifically in Hollywood. And you have to realize that obviously Baldoni in the battle for court of public opinion, whoever is more popular is starting with a massive, massive advantage because people want to believe that their idols are heroes, that their idols are good people. So when you're talking about a team of Ryan Reynolds and Blake Lively versus some relative no name of Baldoni, he's starting from such a massively so far behind the eight ball in being able to get out in front of this story that I agree with Danny. Strategically, this was an essential move for them and a brilliant move. Because
a lot of it too on your line, Joe, is even if he was to lose in court, if the public overwhelmingly believes Baldoni is getting a raw deal, he can work. And
exactly.
The truth is that, kind of like it's the opposite of Johnny Depp in the sense that Johnny Depp lost all of his gigs and then was suing. Baldoni is like throwing everything on the table, I think, immediately to prevent himself from being froze out of everything in Hollywood, which is very smart. So people will feel comfortable hiring him. There's enough public support. They can say, hey, that's a court thing. We can still hire him. There's enough people who like him and will go to his movie just because they're supporting whatever. I want to ask,
especially because it's a Me Too situation, especially because the negative stigma around anyone who's even accused of Me Tooing some woman, that you're so quickly blacklisted by Hollywood and a very vocal segment of the public that if he doesn't get out in front of it to expose from his perspective what are outright lies, he's cooked and he becomes he becomes a mini Johnny Depp. He becomes that ugly figure who no one should be around, and your name starts becoming associated with the Harvey Weinsteins and Jeffrey Epsteins of the world.
Right.
So
to finish what I was going to say, one more little piece. On the anniversary of Saturday Night Live on Sunday, Ryan Reynolds drew some potential attention to the case with a flippant remark when he was asked, "Hey, how you doing? What, did you hear anything?" Would that have an effect on the case as well? Because he's potentially joking about it. And then now, please go ahead. I just wanted to get that question in there.
I don't necessarily think so. I mean, he's already screwed himself over by doing his little nice pool stunt, being a part of the ongoing harassment against him, being used as sort of this, as she quotes, to quote her, as one of her dragons, right? To be used against Baldoni and any one of her enemies. And to be a part of this plan to bury Baldoni is really just disgusting. And I said this on my stream last night. I don't want to be the gal who's defending Baldoni. He's not my type of guy, okay? He's not the kind of guy who I want to defend because he's the kind that when I come into litigation, he'll turn to me and say, but wouldn't that hurt their feelings? And I can't handle that. I can't work with that. But that's the kind of vibe he's giving, and I really appreciate it. Frankly, I think he's a decent person based on everything I'm seeing. I wanted to ask Kurt, do you think that there's more receipts where those came from? Because I feel like that wasn't just, here, I'm laying all my cards on the table. I feel like that was, I'm going to put down 50% of all the crap I have on you. Let's go.
I mean, I assume it's not necessarily complete, but I do assume that it's the best stuff and the most representative stuff. So I assume that the other stuff that would be out there would be essentially duplicative of what was there, or not as strong. I mean, presumably he's trying to make the best case he can with what he has. And the stuff he has is really good. I mean, he's making a very persuasive timeline argument to me. These interactions that he had on set, he's making a pretty good argument to my mind, at least, that they were professional. Like, just for one example, like I was inquiring about her weight. Well, who asks a woman about her weight? Well, if you're lifting somebody because that's part of the script and you have a bad back, you might want to know how much they weigh. So that makes it a professional inquiry. It's like, I'm not asking you because I'm rude. I'm asking you because it's professional. I need to know. I was like, oh, that's a pretty good reason to me.
And what's great is he backs it up by later saying he wasn't able to go to the editing days because of his back infection. Right. So he even further, supports his claim that, yeah, I have a back issue. So of course I was going to ask about this. And not only do I have a back issue, she took advantage of that back issue to squeeze herself in on those editing days and to gain control over the entire set. What I found interesting is that this amended complaint that she just filed like a minute or two late, I can relate. It's interesting because they filed this amended complaint. I didn't see all that many differences from the original complaint, which makes me think, and this is theory land here, that the original witnesses who were going to testify against Baldoni have backed out and said, I want nothing to do with this. I don't know what you're talking about. I don't think that's what he meant. I'm sorry, I'm not going to be in on this. And they want to delay the discovery period as long as possible so that they don't have to actually name names and have these witnesses come in and be deposed. So it's interesting to me that they delayed it. And I think that that's very telling. I also saw that they just filed a protective order over the evidence and over this case going into the discovery phase. So, and this is in line with what they had asked for before, a gag order on the case. They are trying so hard to stick with the strategy that they had. And this is just a new world. We're not playing that game anymore in litigation. You don't get to come out, throw out these random allegations and let them sit there with the public for 3 or 4 years as your career slowly melts away. I think that most attorneys have gotten really wise to that strategy, and we're just done.
Question. From my understanding, there's 2 lawsuits. There's Lively against Baldoni, but then Baldoni's suing the New York Times and he's suing them personally, right? So just real quick to wrap it up, is there a difference in the likelihood of success in, let's say, the New York Times case versus the Blake Lively, Ryan Reynolds case for Baldoni, or the reverse case?
Yeah, I think so. I mean, the New York Times is inherently harder. It depends. Baldoni's theory seems to really depend on the idea that they were in active coordination and that they were writing this article together and there was basically a conspiracy going on. But obviously that's something you have to show that actually happened. So if it didn't happen, if New York Times is just more of a passive recipient, then the actual malice standard gets them a long way. If they were actually engaged in an active conspiracy and they didn't know these things or were even manufacturing these things, obviously their liability probability goes up. But, it's a little bit hard to assess based on what we know, the probability of that. So the New York Times case is a harder one.
Okay.
But there are allegations that the New York Times was involved in the planning and coordination of this.
Yeah.
Even down to editing which text messages were included in their story and which ones were left out. I think back to like November or October. Have you seen that? There are a few internet sleuths who've gone through and looked at the metadata and said, hey, wait a second. Some of these text messages or some of what was produced has been changed, and it's been changed by the editor at the New York Times. And that's dating back to those changes were made in October or November. But all of a very large percentage of the claims of where this case sort of develops happens at around that time. So there's a lot to this, and I'm really excited to see where this goes, because I hope that it goes in the garbage. That's my hope, is that it goes in the garbage. Everybody moves on. Now we know that Ryan Reynolds and Blake Lively are gross. I have no idea. I mean, never trust a guy who gives up Megan Fox for Blake Lively. I guess that's the lesson you learn from this.
Okay. Interesting. All right. So let's jump back into politics again. This is just a quick wrap up, I feel, and moving forward on the whole Eric Adams case. And I'm just going to ask the one question. Nate asked me this yesterday, and we actually got in an argument about it. And it is this.
As always.
Of course we do. We have the best time. If you were Governor Hochul, would you terminate Eric Adams because he's compromised? Actually, it's going to be two questions. Would you do that if you were the governor? And my second question is, do you think it's appropriate that a governor can do it? And I'll give you my answers, and you guys can just lay out whatever you want. My answer is the second one, whereas I don't think the governor should have that right, in my personal opinion, because that's going against the voters. And if the governor has the right to just fire at will any mayor, then why don't they just appoint the mayor? Because that's ignoring the vote. But you guys go ahead. I'd love to hear all your different opinions. Nate, of course, said the opposite. He's wrong, but go ahead, Nate, explain.
Sorry, I was talking to my wife.
Yeah.
No, I think, well, I think the setup has to be, first we have to understand that New York doesn't have what's it called, a recall mechanism. So the only way you can really remove elected officials in New York is the governor has to remove them through kind of this process that they have. When you start getting recalls, this really the further out west. So even though a person voted the person in, they can't vote them out. And then second, with Mayor Adams, I think now, because of the way the process goes, so the process to remove a mayor in New York would be the governor would say that there are some charges and suspend that person for 30 days. That person by law has a notice and opportunity to be heard. So then the mayor would make their case in front of the governor saying, this is the reason why I shouldn't be removed. Then the governor, if the governor chooses to remove the mayor, the public advocate in New York City would then become like an acting mayor. And in 3 days, that acting mayor is supposed to call for an election. And that election has to be held within 80 days of the removal. And in that election, you can have, it's a non-party election. So you can have a Democrats, Republicans. It's not based on party. It's just based on whoever gets enough amounts of votes to get on the ballot. So with that being said, if there was a recall mechanism, instead of the governor, I would support recalling the mayor, because I think the mayor is just unfortunately compromised based on the situation.
Or an impeachment situation.
Yeah, or an impeachment situation.
But another branch, in a sense.
Yeah, I think the mayor is compromised, but then I feel like 2 or 3 ways about it, because even though it's weird, because even though the mayor is compromised, there's like a lot of nuance to it. First, he was actually doing this before the charges, before the Trump administration got it. He was already trying to help ICE before that. So that has to be taken into account. And also the second thing has to be taken into account is that I think the mayor, with these charges being held over him without prejudice, where they can be brought back, it gives the appearance of an impropriety. So should the governor remove the mayor? Well, but then it all just comes to the question, is the mayor acting for his own self-interest? Keep me out of jail for 40 years because he can get 40 years. Or is he acting on the benefit of the people in which he was elected? And I think one of the big differences in this type of plea arrangement, if you can even call it that, is that generally in plea deals, if I did something wrong, let's say committed murder, then I personally would have to be held responsible for that. So let's say they give me community service. I would have to go into the park and do this. But if the court wouldn't allow me to order someone else to go clean the park as a condition of my community service. So in this particular instance, if we're looking at this as a plea deal, essentially Adams is going to be ordering the police department and everybody to do things on his behalf to satisfy his plea agreement, which I think is that it's textbook. It's not appropriate for him to, if he was to be able to do it himself. So forcing him to use that authority in that way, I think is inappropriate for a plea agreement. So should the governor remove him? If I was the governor, I would, but I also think the governor has to understand too the timing of it too, because if she removes Adams now, in June, which is about 80 days from now, there's a primary election for mayor, for the Democratic mayor. So you would have essentially 2 elections at the same time. You'd have a primary election for mayor, and you'd have an election to see who's going to be the new mayor serving from June until November, which obviously doesn't make any sense. So I think if you look at the whole thing in the whole pie, then I think the governor's making the right decision and not removing him now because it's just the timing doesn't work. But if this was maybe a year ago or 2 years ago, I would have removed him. But I don't think it's not feasible. It's not feasible to do it now.
Nate, can I ask
My
you a
read on this
question?
is totally different. But go ahead.
I just want to ask a quick question from a political standpoint, because now we're playing political stuff, and this is fun for me. From a political strategy standpoint, what is your read on the people of New York now that Trump has gotten rid of the congestion tolls? Do you think that Hochul can take another hit? Because my perspective on it, I admit, is biased and skewed. I would think that the people of New York would be in favor of curtailing, or at least being able to mitigate and handle the new residents that they have in the city that they've been unable to deal with. And it seems like Eric Adams is championing taking the money from the feds to at least do that, and fighting back against the Trump administration to make sure that these people have a place to stay, that they're housed somewhere, and then to comply with ICE in the case of criminal elements in those groups. And then you also have Trump, who's getting rid of these congestion tolls. I would think that he would be a little more popular than not right now for the people of New York. And I feel like if she were to remove him, that would backfire. But you would know better than I. So you tell me, what do you think? What's your read on that?
I think your observation is astute. I think the pulling of the DOT's congestion pricing, I think that was a masterful political move that puts a lot of pressure on the governor, because no one like that. No one who lives in New York is going to tell you they like the congestion pricing. And like most people, like Eric mentioned it too, it's a poor tax. It's literally a poor tax.
That was in the side conversation.
Yeah, but that's
yes.
it's a poor tax. It just is taxing the poor.
It's a tariff. It's a tariff against anyone. I mean, a tariff is you're an outsider. We're going to sell your stuff here. In that case, we're going to charge you for it. Over here, the tariff is usually against other countries. This is a tariff against all Americans who don't live in that section of Manhattan. It's a tariff. I mean, it's really outrageous. I do think that the timing of him pulling her congestion pricing, and then the next day or 2 days later, she's threatening his new purported vehicle for getting things done in New York. I do think it was her way of he's a pawn here now. He's almost sympathetic, because it's like he's trapped. Like, what do you do if you're Eric Adams? On the one hand, you want to stay out of jail. You sort of feel like you have to comply with Donald Trump. On the other hand, if he certainly seems to maintain further political aspirations. If he wants to stay on as mayor, he has to placate Kathy Hochul. He's in the damned if you do, damned if you don't situation, and she purposefully put him there. And I think she did that because she looks at him as a pawn that she can try and manipulate. And to a degree, I can't deny the fact that Trump's looking at him as a pawn that he can manipulate, and he's basically
to a degree, to a very large degree, he absolutely. Yes.
Well, we can rehash that debate again if we've been going. Nate and I have been going at that debate all week.
No, it's not a hash. I'm just saying that Trump. It's not even to a degree. Trump absolutely is. Everybody agrees the Justice Department is manipulating Eric Adams.
Right. I mean, you can argue. And here's the thing, though, and I think that this is. I was thinking about this as Nate was talking. It really sort of depends on the nature of what they end up asking from Adams as to whether or not how far he's being manipulated. We've seen how the federal government has been frustrated in various cities across the country, where the local authorities have not simply failed to help them capture criminal illegal aliens. They've actually been giving tips and heads up to the illegal aliens and making it harder for ICE,
which is wrong. It's 100%.
Which is 100% wrong.
Right.
So if the extent of what he's asking for is simply, hey, we just want to know that your department there is going to be free of that type of crap, and that in a city which has one of the largest concentrations of illegal aliens anywhere in the country is actually going to be at least giving us maybe a heads up if they know where someone is going. if they have some sort of tips as far as where they can find illegal aliens. I don't think that you're making it sound as if this is a whole policy shift. That's different than, and then the next step higher than that would be Trump actually sort of, turning them into weapons, who is going to send the NYPD in on behalf of federal agents to go collect these agents. That's the next level type of thing, which is a different type of thing where you're sort of federalizing these city cops. That's a different level, which you could say, okay, now Trump is pushing the envelope a little bit further than what he would get if he didn't have this sort of Damocles hanging over Eric Adams' head. And I do think that would be different. I mean, I think you all agree with me on that, right?
What I want to say is that I think no matter what side the debate came on, everybody agrees the Justice Department is manipulating or holding something over Eric Adams' head. The only argument is whether it was right or wrong. We're not arguing that anymore. We hashed that all out. All I was saying is just reiterating that yes, it's majorly working him. He's being worked on both sides. But I do want to make only a degree. It's a big degree.
But I think it's important to make the distinction where, because you hear a lot of people, even in the chat, would say something like they're just saying he has to follow federal law, right? Adams has to follow federal law. Debo has to follow federal law, essentially making a commandeering order, right? We're just saying we want him to follow federal law and we want him to help federal law. And the problem is that in sanctuary cities, that's their policy, is that we're not going to enforce or help the feds implement federal law. And if that's the premise, right, we're not going to help you. So if we arrest somebody on a routine traffic stuff, we're not going to ask them immigration. We're not going to tell immigration we got them. We're going to let them go. Now, the Supreme Court and matter of fact, all the court systems now has said that is legal. That's legal. You don't have to help, but you cannot. Now, I think Joe made a very astute analysis. He's saying, but you can't hinder the process, like what AOC is doing. Or you do this. If you're hindering or blocking federal agents from doing that duty, then you've crossed the line. So I think in New York now you get to the point where is Adams just going to say, well, we're going to now help, or is he saying we're not going to hinder? And I think that's a really big distinction, because one, technically, is not constitutional. Commandeering state officials to do, if they say no, they have to have that option. But the other one is bad for the state. So it really, I think, depends on what we're talking about. And I think most people are talking about not hindering federal authorities in doing their job. Would that make sense?
Yeah, if they come to and knock, hey, you have these people in your prison. We need to go see them. Yeah, here you go.
That's it. Yeah.
Yeah, but that's not doing anything. That's not helping. That's just
sort of the middle ground there, which is really up for dispute, is that information versus physical assistance. Right. I mean, because commandeering, I agree with you that's in federalizing the New York City cops or other agents working on behalf of the state or city. That's next level, which I agree with you that's really pushing it beyond the bounds. But with respect to information, providing information, like if there is a traffic stop and they see that this is an illegal alien and, potentially someone who's on a long list of thousands of names of people who are potentially dangerous, and then giving that tip to ICE of, hey, we found this person over here and now you're not physically interceding, you're just simply sharing the information. And I think that is not really commandeering them. That's just working as one cohesive unit. And I don't think that's any sort of abuse of Adams or his police force.
Yeah, but what about the fact that there's a city ordinance that says, because the city council, and just so understand how left wing the city council, and again, I want to make it very clear, I disagree with the New York City doing all of this, but they tried to have illegal aliens vote for mayor. But there's a city ordinance that says you can't specifically do that. And I think that's what Pam Bondi's lawsuit against New York City was saying, was that your laws are essentially not
unconstitutional.
They're not about you saying we don't want to help you. They're actively trying to hinder us in the process. And I think that's what people on the left don't understand when we talk about this, because it's the hindering part that the Trump administration, I think, has the issue. It's not the fact that we don't want to do anything for you. Does that make sense?
Yeah, I think the bigger issue outside of the red light laws, the ordinances that you were discussing, that she is going after, she can target, is judges and prosecutors who are undercharging or who are taking out plea deals so that, and states that are passing laws so that they don't become federal offenses, and things that would normally make them automatically eligible for deportation are no longer eligible. So Utah is working right now to change that law back to the way it was here in terms of DUIs. So instead of 364 days, it's now going to be 365 days requirement in jail after your second DUI. And so that bumps it up to, a felony. And it's sad to see the pushback that we're seeing. It's just the level in which the judicial branch is overstepping its constitutional bounds and trying to curb the power of the other two branches, and not only curb them, but make policy for the other two branches and enforce their own laws the way that they want to. It's just a little bit disturbing to me. It's very disturbing to me. I take that back. Whether it's on a federal level, a state level, or a local level, we're seeing it all the way across the board. Whether they're fighting Trump, at a federal level or at a local level, it's still illegal, and it's obviously an abuse of the Constitution. And it's wild to me that we tolerate it, frankly.
All right.
Well, my question is, what federal judges, what role should they have in, like, recently in the Trump administration? I know, like, for instance, I'll use as an example the birthright citizenship issue. So Trump issues the executive order, right? We're going to rethink birthright citizenship to not include people who've crossed over illegally. So their children, if they have children here or not. And then you have
everyone born here. To everyone born here.
So then when you had the Trump administration, so in what they go to Washington, go to district court judge, he does a nationwide ban because they say, well, that executive order can't be enforced anywhere in the United States because it's unconstitutional. It goes against, X amount of years of precedent. I personally agree with that decision, but I know there's some disagreement on the scope and scale of it. Like, some people are saying, well, it should have just been there. It should have just been in that particular area. The decision with the birthright citizenship, like, because of this Supreme Court precedent, Trump goes and says, well, I want to narrow it to this, and then that federal judge says, no, we're gonna hold that because this is what the law has been, and you're trying to change the law, so you need to go to the courts. Now I know the main argument is about the brevity, right? This was a nationwide TRO versus localized into that particular circuit. So I agree with the decision, but I think I disagree with the scope of the TRO being nationwide. So that's kind of
I've long had concerns about the scope of these global or nationwide or universal injunctions, depending on what name we're calling it. It seems odd. We have 94 district courts in the United States, and some of those district courts don't even cover their own state because some states have 3 or 4 districts. So it seems inherently odd that a district judge who doesn't necessarily even have jurisdiction within their own state completely can issue an injunction that has nationwide impact. That strikes me as odd.
But it's because of the nature of federalism, right? This is a federal issue. And so if you start to mess in one corner of the US, you're messing with an issue that is a national issue. And so, whether or not we want judges to be able to have this TRO power is another question. Should one judge in one part of the country be able to put a hold on things? That's the question on these federal issues, major federal issues. Should that be up to a federal district court judge, or should that go a step higher? Maybe only the appeals court judges can make those determinations because their scope is a little bit broader. But either way, those are federal issues. I think in the question of, like, let's say the EPA, right, issuing, let's say that a federal district court fights back against the EPA, and the EPA says, oh, well, in this area, you can drill X amount, and it doesn't affect the rest of the US. The issue I have is that oftentimes the judges tend to go beyond the scope in issuing their TROs, and then they become nationwide bans when those are not federal issues. They're only federal to the extent that you're fighting back against a federal agency and a federal policy. So they're basically saying, look, if you can't do it here, you can't do it anywhere. And I think that goes beyond the scope. And I think the Supreme Court has ruled that way before, but the the district courts continue to do it anyway, and they wait to get overruled because the punishment is the TRO itself. They know that the litigants are going to have to wait till they get back up to the Supreme Court for them to be overruled and be told, you're naughty. And then so what? They get shunned by, some, high-minded thinkers in theory. They don't care. They get to go and wine and dine and, sip their cocktails with their buddies at the end of the day and say, yeah, I really showed him. And then nothing happens.
Life, right?
There is no repercussion. And that's the problem I have.
What about this super chat here about in gun or Pew Pew Nation? My cases TRO only applied to parties in case. Why not have that standard?
Because there's sometimes TROs need to be applied nationally. So I think the argument isn't that we should just disband the TRO, but I think the argument is at what level should a TRO be able to be issued that has that's nationally broad. And I think most of us would be okay. Like if the Supreme Court issued a TRO, then that makes sense. But
that's a co-equal branch of the government.
Yeah. But then there's also an argument though, is that the authority that any district judge, because they're Article 3 judges, any district court judges using the authority of the Supreme Court and acting on behalf of the Supreme Court in that particular role.
The Supreme Court needs to clarify the issue.
That would mean that
one way or the other.
Isn't that Chevron?
No.
Chevron's a lower. No. I'm saying though. Any level of the administration can say I'm acting on behalf of the president and I can just muscle whatever down. I mean,
no, that's a little bit different.
Ways.
Yeah. So the way our Constitution is set up, the judicial branch is the Supreme Court, and there's only actually one necessary justice. That's the Chief Justice. So if Congress says we don't want any courts, you have to have at least one Chief Justice on the Supreme Court. But now Congress has the authority from the Constitution to expand the numbers on the Supreme Court. We've had that issue, and to create lower courts. They call them inferior courts. Now those inferior courts who are created under Article 3 can make determinations on the constitutionality of particular issues. So all those courts are actually acting with inherent authority of the Supreme Court. That's why when you have things like me and Kurt had this argument before, when you have something like the bribery issues or things with the Supreme Court, all those ethics issues, those ethics rules are determined by the lower court judges. The appellate court judges and district court judges have to follow those rules. When it comes to Supreme Court, they don't have to follow those rules because the power for those other judges to act comes through the Supreme Court in that Article 3. So in that sense, yes, Article 3 judges are acting with the authority of the Supreme Court in that particular way. And that's why the Supreme Court has the ultimate authority to either overrule them or keep their rulings alive.
It just seems like, again, too wide of a scope or too low of a level and out of hand. I think that the lawsuits are just pointing out a chink in the armor, or a hole in the system. That's just my opinion. I'm going to shift real quickly. Nik, you had something on Delphi. Unfortunately, I don't know if anybody here covers Delphi or knows much about it.
Delphi. Richard Allen was convicted late last year. And now information is trickling out because it's getting out of the hands of Judge Gull. Now she does everything in her power to not release this public information, also known as the evidence in the case. More or less every news agency in the United States have written in, emailed in, we want access to this. And her
access to what?
Access to the evidence because the trial is over.
Okay.
And she has denied them all because you can't be sure just because you claim you're from CBS. I don't know if you're really from CBS.
Is this the judge or the prosecutor?
What?
Who's denying, the judge or the prosecutor? I'm sorry.
Judge.
Okay. Yeah. I don't know anything about it. All right.
Yeah. And so still nothing released, but it's getting trickled out as the appeals attorneys, they get the information. And also through another denied motion, two denied motions. The motion of correcting error, denied without a hearing, and also a motion on, one more motion, denied without a hearing. But in these motions, we get new information. Mm-hmm. And as it trickles out, we know more and more about what we never knew, so to speak. For instance, we already know that Ron Logan, he lied about his alibi, one of the early suspects in this, because the Abby and Libby was found on his property. And but despite him lying about alibi, lying about where he were, they made a surface search of his property, didn't find anything of interest, and everything went down. But at the same time, Ron Logan was on probation, and he violated that probation, so he was sent to prison for the last few months of that probation. And in that, he talked to another inmate. And apparently, according to this inmate, who then tried to contact the investigators, this was just 2 weeks after the murders, tried to contact the investigators. And they came and interviewed him, and nothing came about it. But now, through new things that has resurfaced, this inmate, Ricky Davis, up until the day the trial started, he sent letters to the prosecutors. Hey, not only have I talked to Ron Logan, I have talked to this Keegan Klein guy who is in prison for 8 years because of PDF things on his phone. A lot of it. And it seems like Keegan Klein and Ron Logan, both early suspects, knows each other. Information he relayed to the prosecution that was never relayed to the defense. So that's an interesting Brady violation in itself. And in this information that has resurfaced since, also it has been mentioned that in the either geofencing or the cell tower dump, they found 2 burner phones roughly at the scene of the murders of Abby and Libby, at the time of the murders. Those phones apparently has also been at another crime scene where 2 girls were murdered back in 2012. The case of Lyrics and Elizabeth in Iowa. And this is information they have had all this time in Delphi in this case, but suppressed it because no nexus.
So just to be clear, you're saying that there's evidence potentially pointing to another perpetrator that they've buried.
2 perpetrators, or maybe even a third.
Okay.
Or even one of them is the owner of the property, whose girlfriend described him as a schmexual sadist.
Okay.
Then the other person is a convicted CP, the distributor. That Keegan Klein is the person who via Instagram had contact with one of the victims in the Delphi murders. So it's all still circumstantial, but this is information that keeps trickling in after Richard Allen was convicted. And so according to the information from this inmate, Keegan Klein said he met up with Ron Logan every 3 to 6 months because they shared CP with each other. And this is information that is completely new to us in the public, but that was known by the investigators and the prosecution, and that was suppressed by Judge Gull. They were never allowed to bring this in as a third-party culprit because, according to Judge Gull, there's no nexus.
Well, okay.
There's no nexus that Keegan Klein, who had contact with the victims, or with one of the victims, had shared CP with Ron Logan on whose property the girls were found murdered. But apparently that's no nexus. And it's getting infuriating, but at the same time, it's getting out of the hands of Judge Gull now. This is getting on direct appeal, and if that doesn't work, it gets to the Indiana Supreme Court. We will get more information as time moves on. But we should have known this. If Vinny Napolitano on Court TV did a special yesterday on this, which I covered in my stream earlier today. And as one of the private investigators said on that show, we the public, we know only 10% of the evidence that was being withheld from us that points to not Richard Allen.
Wow.
So,
Okay. Do any of you guys have any questions for Nik on this? So I noticed very quiet.
He seems to be the one who's knowledgeable about this case and I know nothing about this case. So I sort of feel like he's my educator.
Yeah.
And doing a great job.
Yeah. So, well, this is my surface theory so far. If they can connect all of this to these two people, and especially to Ron Logan, if they can put him in Iowa 2012 with that burner phone, then we might have a person who got away with murdering 4 minor girls.
Wow.
But hasn't that sort of been the defense's argument from day one, that this was someone else and that
third-party culprit, yes,
right? And
the
Odinist claims, and I've looked through the case. I followed it back when the judge was arbitrarily saying you can't be represented by this attorney or that attorney, and then that went all the way up to the Supreme Court. But I haven't followed it since. So, and
then they were reinstated because the Indiana Supreme Court said you can't do this without a hearing.
It was insane.
Absolute. This entire case is absolute.
I have questions about that judge, period. So, and that entire trial.
I heard one of the people who covered the Karen Reed case says he would pray for Judge Bev in the Delphi case. That's how bad Judge Gull is. That even Judge Bev in the Karen Reed case is a saint in comparison.
Wow.
It's just now trickling out. And as the investigator said, we're just getting to the surface because she can't talk about it because she's helping the appellate attorneys. So she can't talk about things unless it gets revealed by somebody else. Then she can talk about it. And then you had Brad from Defense Diaries on it with also more information. And it boggles my mind that all of this was kept a secret from the public. And we barely scraped the surface of all the misconduct. And Ron Lowe, Delphi, Indiana is, I don't know if this has anything to do with it, but just they don't like outsiders. They really don't. I mean, little Delphi, Indiana, with 3,000 people living. I mean, you walk through the town I walked through that town in 10 minutes. And I use a cane to walk. It's really, really small. And in a matter of months, they had 6 minor girls murdered in that little town. The Flora 4 murders, or the arson that killed them, that is still unsolved. I looked through I got the paper sent to me, and also one of these things that boggles my mind. For me, I have a clear suspect. I can't believe if the evidence against Richard Allen was enough, then you have, I mean, a dog pile of evidence against the suspect I have in mind in the in the paper, in the documents I've seen. But the suspect is not an outsider. He's also a member of the local Masonry Lodge, which also, I mean, it sounds so absolutely bonkers that we remember the Satanic Panic in the 90s.
Yeah, 80s and 90s. Yeah.
Yeah, which turned out to be absolute bullcrap. That was the initial thought about everybody.
Well, you say that, but trust me, read
Some
the
of
comments
it
later on. Read the comments here later on, and you will feel the wrath of the finders and other things about that. So, believe me, I interviewed the FBI guy in charge of sex crimes against children at the FBI about that, and that interview got extreme feedback that was not in a positive nature. Now, I want to. That case sounds like a complete nightmare, Nick. Hopefully, you have a documentary or something on your channel that people can check out and learn more. It seems convoluted to me.
About the Delphi case, I had I just 10 minutes ago, while I was waiting here, I released a video about the latest in this case that is at least what is public, and it will just get worse.
Awesome. Okay, so I got one more to go in. Joe put this up, and Joe's actually been very patient this round. Joe shared a letter, which is kind of a funny one, from Robert Garcia, who I believe is a Democratic congressperson.
Correct.
Who got some heat for statements he made that could be interpreted as calling for violence against an American citizen. Would that be a fair assessment, Joe?
Yeah.
Okay. He is now crying that if you make a criticism against the government or Doge, that you're going to receive a letter that I guess he's saying is going against his free speech. You want to take it, Joe?
So if you quickly scan the letter, you see at the end of the second paragraph, the statement which he made, which is what brought him under the attention of the Department of Justice, is what the American people wants is for us to bring actual weapons to the bar fight. This is an actual fight for democracy. I'll tell you right now, if my first read of this was actually to side with Robert Garcia. I am very much as broad a free speech advocate as can be reasonably interpreted. And my first thought was with him that when I reread that statement a second time, putting the words actual in there, actual weapons, an actual fight, does change the context somewhat, because now it's not, if he just said, a lot of times people say colloquially, fight. It's funny that he's saying this when we think about in the second impeachment, how Trump was excoriated by everyone for saying, the whole fight thing, that he was, that's an impeachable offense. And he very clearly was talking metaphorically. Over here, the specific language Robert Garcia is using, when you incorporate the words actual, is saying, I'm not talking metaphorically. So when he's saying I'm not talking metaphorically, I can understand why the DOJ would bring him under this bar
fight. So right. I think it's harder. I mean, look, I think it's ugly, but I still
lean towards free speach. I still lean towards free speech.
This bar fight makes it a metaphor in a sense. So it's like, now it would have been better if he said, bring these democratic weapons.
He just said weapons. Even if he said weapons and didn't say actual. When you say what is the word? What do the words actual mean in this context, other than literally bringing, if muskets or other other weapons of instruments of death? What else could that mean when you say actual weapons? Now, I still think that this is not an illegal statement under the Brandenburg standard, because it's not talking. There's no imminence on time and place. So, and since it's not violating the Brandenburg Standard, I still think that the DOJ should let him go. I don't think there's any sort of incitement here because it doesn't have the imminence of time and place. So
it's rude. It's rude.
It is crude. And I'll tell you something. I don't like the DOJ. There's so many things that the people who are Democrats do, which are really illegal, that I don't really love the idea of them investing a lot of time over here, even though I have very little respect for Robert Garcia as an individual or his political opinions. But at the same time, I don't want to see our Constitution devolve on free speech bases. That's just harmful for everyone. So I don't like the DOJ really going down this road, even though I think he's pushing a boundary, but I still think that he's within his constitutional rights.
All right, hold on. Dani with the flashing camera. What do you have to
Sorry,
say?
I don't even think he's pushing a boundary here. Out of everything that we've heard out of AOC's mouth, out of Maxine Waters' mouth, out of literally and I mean actually all of the freaking Democrat representatives, actual representatives, all of them have said something far worse than this.
Yeah, Maxine Waters is a great example.
All of them.
Because she said to confront people directly. It was a very specific, if you see them at a restaurant, if you get in their face.
You get in their face.
Way far. That's
you
way
go
far.
up to them.
Go fight them. Go fight back. These are actual calls to violence. And so I think that things matter, words matter, and the laws matter. And I think if you start to apply it to every slight or person that you don't like, it makes the law less meaningful and less impactful when it matters the most.
100%.
So I am strongly against this because, even though I think it's distasteful, I think that it's potentially harmful rhetoric to the public discourse. I think that it leads to us hating each other more, not bringing us together and allowing for people to talk. Yeah. And it includes this idea of protecting democracy, which, that's been the call of the Democrats since before Trump was even in office, while he was running his campaign. We need to fight back. We need to fight for our democracy. And that has imbued and empowered extremism. However, the left has turned and said the exact same thing to the right for the last freaking forever. Okay. At least since I was young, the left has been claiming the same thing about the right. So I take massive issue with this. I don't think it's appropriate. I think where there are actual calls for violence, where you are telling people what to do, you're instructing them what to do, there's time and place issues here. I take issue with this all around. I think,
and I will say, while I agree with you, Dani, at the same time, I do agree with Nancy Mace calling to censure him.
Because censorship is fine. Yeah. If they want to censure him, that's fine. By all means, go ahead.
So,
but
because
an actual criminal
it's not appropriate. It's not appropriate type of language. When you say actual weapons, that's not appropriate language for a member of Congress. But as far as it being a legal matter for the DOJ to get involved, that's where I think it's wrong.
Yeah, and if Congress wants to impeach the president because they think that his speech is tantamount to, calling for threats of violence, and go for it. If there is a political mechanism to deal with a political issue, which is what this is, do that. But keep your mouth shut when it comes to a legal perspective. It's very scary to me. This is what's happening in Europe. Look at what's happening in Sweden. Yep. Some guy goes to burn the Quran because his best friend did the same thing. Best friend gets murdered by these Islamist extremists in Sweden. And then his friend, who also burnt the Quran, gets told by the judge that he's the problem. This needs to stop.
I'll do you one better. Did anyone see that 60 Minutes segment recently where they were interviewing the German prosecutors who are going after people because of memes?
Okay, can we resolve to Sweden, because we actually have somebody from Sweden sitting on the panel, and I kind of don't want to leave that hanging out there.
Now we have about 20 of these Quran burners. Most of them nobody cares, not even the major Islamists. The murdered guy was under protective, but he also live streamed.
And
so, no, I'm getting there.
Oh, sorry.
So, so people found out his address. Now, is it wrong? Absolutely. What is not revealed in this is that he was paid to do this.
And
by
I still say
Iran.
and. You know, I really love. No, I don't care. This is what I love.
Yeah.
If you guys go and watch the speech that JD Vance gave in Germany, it is so powerful. One of the things he says is, if you have election interference and your democracy falls as a result of a couple $100,000 or $1 million being flooded in from your political enemies, then how strong is your actual democracy? It must be incredibly fragile. And I don't believe that these democracies are that fragile. I tend to agree with JD Vance. This is not election interference. This is not actual threats of violence, being perpetrated on people or individuals or citizens or elected officials. I'm sorry, but elected officials are even more prone to these types of threats that they're already protected from. The state is there to protect them. They have Secret Service. They have that type of guardianship. We would roll our eyes if this type of case were to come between two individuals in, bupkis nowhere. We would say this is an insane case because we know that it's not a threat. That's my general test. If we know it's not a threat in bupkis nowhere, then it's not a threat anywhere. I'm sorry. And in the case of the Quran burning, I don't care if they're paid. I don't care. You should be able to burn any Quran, burn the Torah, burn the Bible. I don't care. And it pisses me off.
Did you hear by whom he was paid?
I don't care if it's from Iran. I don't care if it's from Russia.
So
I don't care if it's from every political enemy in the world.
If a supposed anti-Islamist is burning Qurans paid by the Islamic dictatorship of Iran and is then killed by Islamists connected to Iran, you don't care.
I don't care, because the fact is he's accepting payment. It's still his speech. He's making that choice. Nik, he knows he could be murdered. Okay. Anybody who goes to burn a Quran knows they could be murdered. I think it's important and vital that people be able to do those types of acts, be able to say what they are thinking without the threat of litigation, certainly without the threat of death.
I don't like that phrasing. No, he
here?
could be murdered, and sort of implies that he was at fault. That the victim's at fault for being murdered. I don't like that phrasing.
What do you mean?
I'm curious if you guys are arguing past each other.
What?
Well, because you said like he did this knowing he could be murdered. The way that I hear that is it's victim blaming, because you're saying because he did this, he should be willing to be murdered.
No, he's a martyr for free speech. He's willingly taking on that risk, which the risk should not exist. The risk should not exist, but he's very well aware of the risk. What do you want him to do? Pretend like that's not a risk? That's not victim blaming. It's saying he's a martyr for the cause of free speech. God bless him, for all I care. You know what? The rest of them all can go to hell. Anybody who says that this guy is somehow, a victim of his own making, etc., go screw yourselves. Okay. This guy has fought to protect Christian lives all over the world. And you can't say that all of his speech was paid for. There were 70 Christians who were just beheaded in Africa, and it's nowhere on the news. Nobody's talking about it. They're just now talking about it. That happened a week ago almost.
I feel like there's two threads.
Sorry, I don't mean to go off on it. It's
no,
just,
I don't want to jump in.
Here's the thing.
Speech creep going on internationally. That's my concern.
He is, in my opinion, he was paid by Iran and then killed by Iran. In my opinion, he was never a Christian. He was a plant to sow this into Western communities. And now he's a martyr, apparently.
He sowed it in Iranian communities too. There's people in the Middle East burning their Qurans because of him. So if that was the plan, it was a bad plan.
Well, I'm going to stick to he's dead. He shouldn't be. Whoever is behind that should go to prison, but we shouldn't suppress the speech. That's going to be where I'm going to sit on that one.
Yeah, I agree.
The Swedish laws on this, it's weird, because all the different actions he made in itself is not illegal. He was convicted by the combination of actions that resulted in a combination which led to our weird hate crime laws here.
I mean, the only thing I could see that would make sense to me is if he took money from Iran and like that's prohibited because there's sanctions, then you could prosecute him theoretically for that, for accepting money from Iran. But You still wouldn't prosecute him for the speech. You accept it. You prosecute him for accepting the money.
I would want to go after Iran
according to
personally
U.S. laws,
for
but
paying
now
it
we're
off.
talking about Swedish weird laws because we have a hate speech laws here that is bonkers.
Yeah, I
Absolutely
mean,
bonkers.
as I was sort of saying when I was talking over Nick, or we were talking over each other rather, I'm sorry. I was just watching this segment from 60 Minutes where they were interviewing these German prosecutors who were talking about this guy. They actually showed the raid happen. 6:01 in the morning, the police go to do their search. They go into the guy's house and arrest the guy for basically a meme. They arrest him because he insulted somebody. For an insult, they arrested this guy, and the German prosecutors are basically
celebrating it.
They're celebrating it. They're sitting there at the table saying how great it is that this guy's being arrested, and how in one case they say like this guy called someone else a penis. He used the German word for penis, and because he used that word, I don't know, because he used that word and called someone a penis, that is unacceptable, and he should be prosecuted. We should seize his cell phone. He should get jail time and all the rest of it. And the German prosecutors are saying how wonderful this is. I'm like, what the heck are you guys doing over there in Germany?
And CBS is platforming them to celebrate it, essentially saying we need to have that here.
Yes, and the FBI celebrated it here in Provo. There was this old guy. He was like 82 years old, used a walker. He put out some spicy memes. He put out some threats online. They're baseless. The FBI knew this because they investigated him. I think it was in like February or January. And then President Biden came to visit in, I want to say June or May or June. And they came to raid his house at 5 a.m. in the morning, knowing that he was well armed. And I think it was the intention of the FBI to eliminate this threat rather than acknowledging the guy wasn't a freaking threat in the first place. He had a ghillie suit. The guy couldn't even get into his own car. The guy could barely walk from church to his car. Okay. And he said to the FBI, F off every time the investigators came to his house. And they were like, well, that's just more proof of a threat. And it's like, okay, can we live in the world of reality, people? Like, can we just stop stretching speech to stop stretching other people's speech to justify your bad acts and to justify your paranoia? I'm done with it. I'm over it. That's all I wanted to say. This free speech creep is happening everywhere.
And this is why I not constantly, but when I get the question, protect your First Amendment, because once it's gone, it's gone. It will never come back. Because I mean, just a few days ago, there was a new a judge. Where was it? Who ordered a newspaper to take down their.
That was good.
To take down their opinion they published.
That was such a batshit crazy ruling on so many legal levels. It made my mind hurt.
Yeah.
Was it Schiff?
It was Mississippi. It was a Mississippi
and
judge.
New.
Yeah,
you have that.
Didn't make any sense.
Yeah. You have the raid on the newspaper in another last year.
Oh yeah, I remember that.
And then, however you feel about Aidan Kearney, the Turtle Boy, he's a reporter. A very aggressive investigative reporter.
Okay, I got to say that raid on the newspaper, though, it wasn't quite about free speech and free press. That was, you're exposing our corruption and we're going to strong arm you. Just to be honest here. So, I mean, granted, the journalists have the right to say it, but let's be honest. It was pure corruption. Like they're going after the department. We're going to crack down and search your place and strip all the material. Slightly elevated.
No, that's what they did to James O'Keefe's old outlet. To Project Veritas. They did it to Project Veritas. They've done it to multiple news outlets, and it's been happening nationwide for decades. And these judges are not held accountable for infringing on our rights, because the rights of the press are our rights. This is a collective right to the press.
And that is why it's important to support independent press in countries that doesn't have it.
I'm sorry, Nick, say that again.
And that is why it's important to support independent press in countries where their government does not like independent press.
100%. If we lose it here, we've got the strongest First Amendment. Nobody else has the First Amendment, as far as I
Nope.
know, and everybody else has a derivative of ours. So if ours gets weakened, you all suffer.
But ours is older, but yours is better.
Well,
the
and
Swedish freedom of press.
Ours
It's
is
older,
real.
but yours is
Ours
better.
is real.
my whole point of saying this is when I read that letter, my concern is that they are taking the angle of, well, if you're going to kick low, if you go low, we'll go lower. And that's a concern I have, is you can't be doing tit for tat when it comes to our rights and our freedoms in this country. You want to tit for tat on political issues, you know, firing a mayor that you don't like, going after a policy that you don't like, you know, trying to impeach the president because you don't like what they said. Okay, fine, go for it. But when you're using law enforcement to crack down on anyone's free speech, that's an attack on all of our free speech. And that's my concern, is now that we're in power, we need to very vigorously defend and protect our rights, even more so. The need for us to be honest when it comes to our legal and our law enforcement is even higher than it was under the prior administration. And we should be speaking out even more under our own administration than the prior administration.
We should certainly be highlighting problems or things that don't make sense or that are legally wrong and mistakes. I mean, that's a good thing to do in any environment. So sure. Yeah, 100%. We've lost our host. Lol.
We lost Joe too.
What's our next topic? Okay,
did you guys talk about let's see, you talked to executive orders. Oh, what's his name? I think is going to be making an appearance today, the CEO killer.
Luigi.
Or no, not
yeah.
Baldoni. What's his name?
Luigi,
that guy. That's right. Yeah.
Oh, did you see the line outside of the courtroom?
I'm
dozens of pretty ladies lining to get into the courtroom. It's so stupid. But
what is going on in these women's head?
Yeah, we have a saying here in Sweden that the most beautiful women you find in the visitation rooms.
I guess they really do like the bad boys, man. Woof.
No, they don't. They like their ideological white knight. That's what he is for these liberal ladies who are like, oh my gosh, finally a man stepped up and took accountability and did his job. Like, that's my role. That's my take on it. It's gross.
So they like him because he's masculine? I thought the left didn't approve of that.
No, but he's righteously masculine. That's the thing.
No,
he's on their side.
Who are you talking about?
Luigi.
Yeah, then you also have that swastika guy who was convicted of double murder 6 months ago. He now has a girlfriend.
Who?
Oh, well, yeah.
Oh, the guy who killed 2 women down in.
Look up the word hybristophile and it all makes sense. Or hybristophilia.
I don't know if it'll make sense ever, but
well, no, but I'm just saying that there is a thing of women.
So what you're saying is I need to do more murders.
I would never advise that directly, but everybody.
Dudes are into this too.
Right?
Too many dudes are into these types of crazies too.
So, right. Well,
yeah, it goes both ways. I see.
Yeah. All right. Well, on this wonderful dark note, we'll have Kurt tell us, what do you have coming up?
Yeah, so we're just going to be continuing to cover things as they break down. We still got the rest of the Baldoni Lively lawsuit to break down in some parts. We're also working our way in pieces through the Garth Brooks case relating to the hairdresser that accused him of Me Too. Still working through that case in pieces. Also, of course, as the U.S. Supreme Court or Court of Appeals have cases from time to time, we'll be covering that. Next week, we're going to be having a hearing on Karen Reed. The judge suspended the hearing this week because she seems to be concerned the defense withheld information relating to their cooperation or arrangements with ARCA, which was at the time working for the federal government. And so there's some issues there potentially with the defense not necessarily revealing things they were supposed to reveal. The judge got so mad she suspended the hearing. So we're going to tune into that to see what's going on with that. And otherwise, just trying to cover the legal news. Of course, continuing to cover Trump press conferences and executive signing orders for the foreseeable future, because it's just endless content. So probably many of those things we will cover here on Uncivil Law.
All right. Dani, what do you have coming up?
We are also covering Karen Read. I have a question for you real quick. Sorry, Kurt, because we didn't talk about it during the stream. Do you think, my opinion is that there's something that was not disclosed publicly at that hearing, that wasn't discussed publicly, that was somehow passed to her during the break? And that's what pissed her off.
Yeah, it's not exactly clear exactly what the source of her contention is. Is it just this payment that was not disclosed, although the letter was undated, so it's not clear even when this payment occurred? Is it that they withheld information that ARCA withheld information relating to their sources or data, or didn't disclose the basis of their opinion in court, and that was the problem? So yeah, something happened during that break. Probably it was a very long break. So the judge, the most charitable interpretation is the judge feels like she's been tricked because representations were made by the defense, potentially leading to those witnesses being allowed to testify in an incomplete way, or things that were withheld. And if I were the judge in that situation, I'd be really mad too.
Well, I'd be mad if I thought it was the FBI that had handed that over, which is what the Commonwealth lied about. Straight up, and I say lied because they spent 10 minutes arguing that there needs to be mutual disclosure on the basis of this failure to disclose.
And I don't, for the life of me, understand, because he said the defense turned over the emails from ARCA to him. Like, why would a defense lawyer ever do that? That's work product, right? I'm talking to ARCA as a potential expert witness. Why would I ever disclose those emails to the prosecutor or anyone else?
They did it, I think, because they were showing that they were conforming with the judge's order, and they were basically letting them know, we're going to call him as an expert witness now in this case. So that's what I think happened. And I just I found her outrage only justifiable if there was something else. I couldn't understand that.
You could pry those emails out of my cold, dead hands. Those are protected work product. Go away.
All right, Nick, what do you have coming up?
Oh, wait. I'm not done. Okay, so we're covering Karen Read. We're also covering Baldoni. We are through most of his complaint. We're just covering the second half now. We do this in like marathon style. So we do 3 to 4 hours. Pop in, pop out, come and enjoy, learn a little bit about the law. And then we also are covering everything dealing with the presidential executive orders, because that's a huge legal change, nationwide law changes. Also, President Trump, I don't know if you ever listened to this. I don't know if you ever will. I don't know if Elon Musk is listening, but please, can we get rid of the SEC's FinCEN rules against small businesses and the whole beneficial owner rule that they still are kind of shaping and requiring that we all comply with by March? That would be great. Everybody who has a small business, go and take a look at that yourselves. All right, that's it.
Nick.
Yeah, if you can bring up the picture.
What? Hold on. What am I? Oh, okay.
This is Dexter. He was adopted from a shelter in Florida on May 10th, 2024. According to his new owner, he disappeared May 11th, 2024. May 15th, 2024, his decapitated body was found.
Oh, good Lord, dude.
Yeah.
Gee, what the?
Okay, come on now.
Why? I love how I say 70 Christians decapitated, no reaction. Dog decapitated. Oh my God.
It's the John Wick thing, right? It's the John Wick thing. No one cares about the hundreds of people, but you kill a dog, we all get outraged.
Yeah.
Oh, Stalin, I think, said that too. That killing
the trial against Mr. Rodriguez is taking place right now. I'm covering that case. I will continue that stream in an hour.
Good luck with that. I don't know how I don't know what kind of a draw that one's going to be. I'd be very curious to see how many of you watching that. Even going by the reaction here. What else do you have going on?
I don't think Nick is allowed to talk anymore. I think his free speech rights are suspended on this.
Yes.
Justice for Dexter. Justice for Dexter.
Oh, that was a great opening, though, Nick. You should definitely be on the prosecution team there.
I got a reaction. Might not have been the one I was searching for.
Wow.
Yeah.
Yeah. All right, Joe. This is a perfect lead-in for you.
How do you follow that up? That's a real good question, Joe.
It's your turn, Joe. Come on. Talk and talk. Go.
I'm just going to say this. A lot of things I was holding back during the course of this stream because politeness dictated it, whatever. I don't, whatever I'm covering, no one gives a damn. What I want to tell you is this. The constitutionality of that birthright citizenship EO really comes down to how you look at the Constitution. I'm going to use my time for this. Just tell you really quickly on this. It depends on how you look at the Constitution. If you look at it in the way the left loves to look at it as some living, breathing body, in that case, you can say over the course of time, it's morphed into being anyone born here has citizenship. If you don't look at it from that context, though, everything that Trump has said about birthright citizenship is squarely on point with the law. If you look at it as an originalist, which means what was the original intent of this? The original intent of it had nothing at all to do whatsoever with enabling someone who steps onto our property, onto American soil, to pop a baby out of their womb and all of a sudden say, oh, that's an American citizen. That was ridiculous. It was all about freeing the slaves. If you look at it from a textualist position, there's no support for this whatsoever. So everyone wants to say that, oh, yeah, for sure, this is unconstitutional. What's he thinking? Oh, my gosh, I can't believe that he actually is trying to break the law. He's so unconstitutional. He's throwing out the Constitution. No, he's actually within the bounds of the Constitution. All the people who are arguing against him don't know the first damn thing that they're talking about. That's
Amen.
Okay. You know what? That's
my show. That's what my show's about.
All right.
I agree with Joe. I'll go watch your show.
Oh, no. We're going to close out with it because Joe, I saw you say, oh, I completely disagree, blah, 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 with Nate on this subject earlier. So hold on. So comment below and also use hashtag LBL topics. Do we want to have the ultimate showdown about birthright citizenship between Joe and Nate? I mean, we've had a week break from the last fight. Shall the next fight be about birthright citizenship? And oddly, Joe, I think Barnes actually is on the opposite side of you too. I don't know if you knew that. It's interesting.
Everybody's entitled to be wrong.
Everybody comment below. Do you want to see that as the next fight? I want to hear from you, and maybe we'll do that next week. It could be something we could be queuing up. And we will see you then.